Imagine getting a phone call from your child's school, and the principal can barely get the words out. He's stammering, choosing his words very carefully, telling you there was a unique situation involving your 6-year-old being poked with an unknown object. You take him at his word. You assume maybe a stick, maybe a pencil, maybe some minor schoolyard roughhousing. You hang up and wait for the follow-up call. And then, more than an hour later, the truth finally comes out. It wasn't an unknown object. It was a used diabetic lancet, a needle, and your first grader had been stabbed in the back with it at lunchtime. And nobody cleaned the wound, nobody put a bandage on it, and the child who did it, he was sent right back to the same classroom as your son. That is exactly what happened to one Michigan family, and the legal and medical nightmare that followed is something every parent needs to understand. Let's start with what we're actually talking about here, because this story involves several layers that make it far more serious than a typical schoolyard incident. A diabetic lancet is a small, sharp medical device used to prick the skin to draw blood for glucose testing. When one of these devices is used, it carries biological material, blood, from whoever used it last. That means when a child is stabbed with a used lancet, there is a real, legitimate medical concern about the transmission of blood-borne diseases. We're talking about potential exposure to HIV, hepatitis B, hepatitis C, and other serious conditions. This is not a dramatic overreaction. This is standard medical protocol. Hospitals, clinics, and occupational health offices treat needle stick injuries as urgent situations requiring immediate evaluation and often follow-up testing over several months. Now layer on top of that the fact that this happened at an elementary school during lunch with staff present, and the wound was never cleaned, never treated, and the parent wasn't told the full truth for over an hour. The stakes here are enormous, medically, legally, and emotionally. A 6-year-old child is now waiting on blood work results that will determine whether he was exposed to a potentially life-altering illness. His parents are living with that uncertainty. And from a legal standpoint, the school's handling of this situation may have crossed some very serious lines. So let's walk through exactly what happened, step by step, because the details matter enormously when we start talking about legal liability. A 6-year-old boy was sitting in the school cafeteria during lunch, sometime between 11:40 and noon. Another child the same age approached him from behind and stabbed him in the back with what turned out to be a used diabetic lancet. According to the child who did it, he found the lancet on the playground. Think about that for a moment. A used medical needle was just sitting on a school playground, accessible to children. That alone is a serious safety failure. After stabbing the boy, the other child showed no remorse and immediately tried to get rid of the lancet by tossing it. Another student witnessed this, picked up the lancet, and handed it to a staff member who was attending to the injured boy. So at that point, right around noon, the school staff had the lancet. They could see it was a medical needle. They had a child who had been punctured with it. What did they do? Apparently very little. There's no indication that the wound was cleaned with soap and water, no antiseptic was applied, no bandage, no immediate call to the parents with the full and accurate information. Instead, the principal waited nearly an hour before calling the mother. And when he did call, just after 1 p.m, he described the situation in a way that was, to put it charitably, misleading. He said there had been a unique situation on the playground, not the cafeteria, the playground, involving a student poking multiple children in the back with an unknown object. The word needle never came up. The word lancet never came up. When the mother asked if her son's skin had been broken, the principal told her her child was fine. Fine. Not we're not sure yet, or we're treating this as a precaution, just fine. And the mother reasonably took the man at his word. It wasn't until 2:15 p.m, more than 2 hours after the incident, that the principal called back and admitted it was a needle. And at that point, the story had changed in another significant way. Suddenly, the mother's son was the only victim. The principal claimed he had just not had his facts straight earlier and had jumped the gun by mentioning multiple children. But here's where it gets even more troubling. The boy later told his mother that several other children who had not been near him during the stabbing, were pulled out of class briefly that afternoon. Which raises an obvious and deeply concerning question. Was the school quietly assessing other potential victims while telling this mother that everything was fine and that her son was the only one involved? The mother immediately went to the school, pulled her son, and took him for medical care. When she arrived to retrieve her child, hours after the incident, she discovered that nobody had cleaned or treated the wound at any point during the school day. She also found out that the child who had stabbed her son had spent the rest of the school day in the building and had been returned to the same classroom as her son after assaulting him. And when the family went back to the school to retrieve the lancet so they could show it to the pediatrician, her son came face to face with the child who had hurt him, right there in the principal's office. The following morning, because of the delay in being told the truth, the boy had to undergo blood testing for blood-borne diseases. Those results were still pending. The family was also told on Thursday that the other child had been suspended, but they weren't told for how long. Now let's talk about what this family's legal options actually look like, because this situation involves multiple potential claims. The first and most immediate issue is the school's duty of care. Schools are legally required to act in the place of a parent while children are in their custody, a concept known as in loco parentis. That duty includes basic first aid, accurate and timely communication with parents, and creating a safe environment. Failing to clean a needle stick wound, failing to accurately disclose what happened, and failing to promptly notify the parents of a medical emergency are all potential breaches of that duty. If those breaches caused harm, and ongoing medical testing and emotional trauma are absolutely forms of harm, then the school district may be liable. The second issue is the question of negligence in allowing the lancet to be on school grounds in the first place. If a used medical needle was found on the school playground, how did it get there? Was there a failure in maintenance or supervision? Schools have an obligation to maintain safe premises. A used needle accessible to children is not a safe premises. Third, the deliberate misrepresentation by the principal is significant. He did not just withhold information. He actively described the situation inaccurately, used language designed to minimize what had happened, changed key details between calls, and told the mother her child was fine when there was an active medical concern. Depending on how this is characterized legally, this could support claims beyond simple negligence. In Michigan specifically, school districts can be sued under certain circumstances despite governmental immunity protections. A personal injury attorney experienced in school liability cases would need to evaluate whether the district's actions fall within one of the recognized exceptions. It's also worth exploring whether there are reportable violations to state education authorities or child protective services given the nature of the injury and the response. Here's what this family and any family in a similar situation should do right now. Document everything. Write down every call, every conversation, every timestamp. Save all voicemails. Get copies of all medical records. Request all school incident reports in writing, and keep copies of any communications with school administrators. Do not rely on verbal conversations alone. Follow up every conversation with an email summarizing what was said so there is a written record. Contact a personal injury attorney who handles school liability or premises liability cases as soon as possible. Many offer free consultations. The statute of limitations in Michigan for personal injury claims is generally 3 years, but cases involving government entities often have shorter notice requirements, so time matters. File a formal written complaint with the school district and the state's Department of Education. Create an official paper trail. This protects your child, and it may protect other children at the same school. And if blood work comes back with any concerning results, that changes the scope of potential damages significantly and needs to be in the hands of an attorney immediately. If something like this has happened to your child, whether it's a school injury, a negligent staff response, or administrators who misled you about what happened to your kid, you have rights. Your child has rights. and the institution responsible for their safety has obligations that cannot just be waved away because a principal didn't want to have a hard conversation. This mother did everything right. She asked questions, she sought medical care immediately, she went back for evidence, and she refused to let the story be buried. That instinct to push back and demand answers is exactly what every parent needs in a moment like this. If this video helped you understand what your options might look like, please subscribe for more real legal situations broken down in plain language. New videos every week covering the cases and questions that actually affect your life.